Good evening, everybody. This is Advocate Shraddha Dalvi. We'll be starting our lecture at 5:05. Thank you. Good evening, sir.
Yeah. How can I get the video? Or there is something?
There is one icon of webcam. You just have to click that. I mean, at the bottom, there is speaker, earphone,
Yeah.
and one webcam. Just click on that webcam.
I've done share webcam.
Yeah, that's right.
So how many people have you got?
Sir, actually, we are
muted.
parallelly we are
आपकी
streaming in
आवाज़ सुनाई नहीं
YouTube
देगी।
also. So there, because we have got more than 250 people.
Okay.
So we are streaming at YouTube also. So in this site, we have less numbers, but in YouTube, we'll be having more.
Okay. Can YouTube be accessed by anybody or is just restricted to you?
No, that is we have kept for open for everyone. So I'll be sharing that in the groups and all.
Yeah. Can you give it to me so that I can share it?
Yeah, I'll just forward you that.
Just forward it to me so that I can circulate it.
Yeah, sure. So your webcam is not visible yet.
I don't know. Start sharing.
Rahul, can you just help, sir?
Rahul, can I hear you? Can you hear me?
You are unmuted. अब आपकी आवाज़
Okay, now
सुनाई
it's
देगी।
on. You got it? Yeah, it's okay. You got it now? So Rahul, Shraddha, you can see me now.
Yeah,
It's
sir.
okay?
Yeah. Now I can see you. Okay, good evening, sir. Just give us 5-10 minutes. I mean, it's
No
like
problem.
we'll be starting our lecture at 5.
Just give me the YouTube link, please. Huh?
Yeah, sure. I'll just send you in 5 minutes. Yeah.
Please.
Thank you.
Thank you. यूट्यूब पे लिंक है। इन्होंने बड़ा स्मार्ट करा है, यूट्यूब में डाल दिया। बंगला साहब में सारी पुलिस अंदर, क्या परिक्रमा का चक्कर लगाया।
A warm welcome to everyone.
Good evening, welcome everybody.
Yeah, before we start with our lecture, I will request Advocate Vaishali Tikle to give a small brief introduction about sir.
Thank you, Shraddha. Good evening, sir, and a very warm evening to one and all connected to this 13th webinar series. I take this opportunity to introduce today's speaker, eminent and renowned lawyer, author, and legal analyst, Advocate Anil Malhotra, sir. The topic today he will be covering is parentage, child custody, gender and equality, socio-legal perspective. Advocate Anil Malhotra is practicing advocate in India since October 1983 at Punjab and Haryana High Court at Chandigarh. He also appears as counsel in Supreme Court of India at New Delhi and before other high courts, commissions, boards and tribunals all over India. For over 25 years, Sir has had extensive exposure in handling civil, matrimonial, criminal, and overseas litigation on behalf of non-residents Indian residing abroad. Sir is also a member of Lavasia International Law Association, International Bar Association, Commonwealth Lawyers Association, and Indian Society of International Laws, besides being country representative in family laws, Lavasia. Besides practice, Sir is also a teaching. Sir is also a teacher and was retained as part-time lecturer, Faculty of Law, Punjab University, Chandigarh, from 1986 to 1992 for teaching professional subjects to final year LLB students at the Department of Laws, Punjab University, Chandigarh. As an author, Sir has, to his credit, substantial published work in international legal journalists on issues relating to interparental child abduction, surrogacy, human smuggling, and other issues of Indian matrimonial laws. Now, friends, without any further ado, I invite and request Sir to enlighten us on this topic. Welcome, sir.
Thank you. Thank you very much for the warm introduction. Greetings to everybody. I am speaking from Chandigarh and would be very happy to share with you thoughts, views, and perspectives on issues of the topic concerning parentage, child custody, gender inequality. And we will look at some perspectives which are socio-legal, and broadly we will, as requested, I will look at joint and shared custody, child psychology, in such litigation, post-litigation issues, then the rights of the child being the paramount consideration in all such custody matters. Then the role of lawyers who handle such matters is very important. And then what happens to foreign court decrees in this perspective, both in country and outside country. Now, friends, before I start, I want to share with you something very interesting, which is what is perhaps going to be the future in matters of child custody. In a proceeding in Delhi High Court on Friday, 24th of April 2020, an Honorable Single Judge, Justice Najeem Waziri, has passed a very interesting order regarding shared custody and shared parenting, or access, whatever you may like to call it. Now, this is a case in which there are 3 girl children, 10, 7, and 3 years of age. Now, the custody of the children is with the father, and the mother had moved the High Court for access by video conferencing since physical contact is not possible. Now, the court has granted a very novel relief. Now, the court has said that the respondent father shall ensure that there is a computer installed in the room where the children are, in the children's room, where they will be free to access their mother on Skype, etc., and would be able to speak to the mother whenever they desire or whenever the mother desires. And the court says the respondent father shall ensure that the computer is in constant working condition with regular internet connectivity. He shall be absent from the room whenever the children are speaking to their mother. The children shall be free to keep their room door closed but not locked from inside, so that they have unrestricted or unhindered conversation with their mother, especially keeping in mind that they are minor girls. Now, why does the court do this? The court says, for a healthy emotional quotient and robust psychological health of the children, the mother should be provided unhindered access to the daughters, if not physically, then through video conferencing for the moment. Now, the most interesting thing is that the counsel for the father has assured the court that the said arrangement shall be made and the petitioner mother shall be provided connection with access to the children as directed in the case of difficulties. The learned counsel for the parties will coordinate between themselves. Now, friends, this is going to be the future of cases concerning children. But in the wisdom of the Delhi High Court, this has happened. Another very interesting thing which the Delhi High Court has done is that on 26th of April 2020, the Registrar General has passed an order removing the extra urgent and very urgent issue of fixing cases for hearing, and has directed in a list, inter alia, matters concerning the Domestic Violence Act, matters concerning custody, maintenance and visitation rights to be listed for hearing by video conferencing. In matters where both sides are appearing, which are ripe for arguments and in which both parties consent to a hearing. So the method, the medium of regular hearing in cases, in matters where children are at stake, has started. I think the Delhi High Court has shown the lead, and this is something seriously I would think that countries should follow. Now, this brings me to a very interesting quote of Lord Alfred Tennyson in his famous poem, The Memoriam. It says, "Now it so runs my dream, but what am I? an infant crying in the night, an infant crying for the light, and with a language and with no language but a cry. So friends, this is a situation in which we are pitted, and this is how it comes up in the perspective of child laws in India. Now friends, if children are our future, then why are we not trying harder to find solutions for them? Is it easier to build strong children than to repair broken marriages? Children make your life very important. Now, it is in this perspective that in the future we will be now looking at virtual child rights jurisprudence in e-courts with virtual distance, and how will we devise joint custody with shared parenting and gender preferences is something which is going to occupy us all, and all of us perhaps will have to assist the court in innovating and in finding ways and means on how we are going to deal with these issues. But friends, let us first see where is the foundation of the rights of the child. My focus, my perspective to you today is on the rights of the child, because in my humble view, the jurisprudence which we have to develop is a child-centered jurisprudence. In matters relating to custody of children, other than matters when there are issues of domestic violence or matrimonial rights, it is not the rights of the parents, it is not the rights of the spouses which are to be decided. The child is not a trophy. The child is not a pawn to be used in a custody battle. So it is in this perspective, the foundation for this, very few of us may know, is in the Directive Principles of State Policy. And in Article 39 of the Constitution, I read an excerpt. It says that, though we all know they are non-justiciable, but still, the state shall in particular direct its policies towards securing that children are given opportunities and facilities to develop in a healthy manner, and in conditions of freedom and dignity, and that the childhood and youth are protected against exploitation and against moral and material abandonment. Now, friends, there are two international conventions in the perspective. The first is the Hague Convention on Civil Aspects of International Child Abduction, which India has not signed, which 100 countries have signed. We'll leave that apart for a moment. The second convention, which India is a signatory to, and on the plank of which the entire rights of children rest, is the Convention on the Rights of the Child adopted by the United Nations General Assembly on 20th of November 1989. And friends, this convention was ratified by the Government of India on the 11th of December 1992. Pursuant to this, we have made amendments in our laws, but the fulcrum, the foundation, the basis of child rights jurisprudence in India rests on the UN Convention on the Rights of the Child. I have successfully been able to advocate the applicability of this convention in 3 recent matters, and happily and luckily, even the Supreme Court is now talking of a child-centered jurisprudence and the rights of the child vis-a-vis the UN Convention on the Rights of the Child. But to understand the perspective from where this comes, the UN Convention preamble, I'm going to read parts of it. It says, the state parties to the present convention, convinced that the family as the fundamental group of society and the natural environment for the growth and well-being of all its members, and particularly children, should be allowed and afforded the necessary protection and assistance so that it can fully assume its responsibilities within the community, recognizing that the child, for the full and harmonious development of his or her personality should grow up in a family environment in an atmosphere of happiness, love, and understanding. Bearing in mind that, as indicated in the Declaration of the Rights of the child shall, by reason of his physical and mental maturity, need special safeguards and care and appropriate legal protection, taking due account of the importance and traditions of the cultural values of the child, recognizing the importance of international cooperation, of living conditions in the country, etc., have agreed to as follows. Now, the UN Convention on the Rights of the Child is talking about, in the articles, I'll not go into the details because that will be pretty long, but it basically, it assures to a child a right to life, that is a right to a family life, a right to an identity, nationality, name, family relations without unlawful interference, and not to be separated from parents. It ensures an expeditious family reunification and speedy decision on child's place of residence if parents are living separately. The child is not to be deprived of family environment and right of direct contact with both parents. Now, just to fill you in, the judgment of Justice Sen regarding the rights of an unwed mother to passport and then birth certificate with in the name of singular name of the mother without the father being named, based on this UNCRC, is well known in the celebrated judgment of the Supreme Court in ABC versus State. It's a 2015 Supreme Court judgment. But otherwise, there is also a clear judgment of the Supreme Court in 2008 that says that if India is a signatory to an international convention, ipso facto, the terms of the convention are applicable to domestic law. Now, friends, it is with this background that we come to principally where the legislation was brought in to give teeth to the convention. You all know that we have the Juvenile Justice, Care or Protection in Children Act, which was enacted in 1986. Then it became the Act of 2000, then it became the Act of 2010. Now it is the Juvenile Justice, Care and Protection of Children Act 2015. Now, the 2015 Act incorporates all the provisions of the UNCRC in the law applicable to children in India. Principally, the JJ Act applies to two categories of children. One, children who are in conflict with law, that is often abandoned surrendered children, also besides that, and children in need of care and protection. Now, who are children in need of care and protection? This is finding definition within section 214. Now, if there is a child who resides with a person, whether a guardian of the child or not, and such person has violated any other law for the time being enforced for the protection of the child. So if there is a child whose parental rights have been violated, maybe even by the other parent, broadly this definition will cover such children. And this has been successfully followed by the Supreme Court in Lahari Sakhamuri, a recent judgment given by Justice Khanvilkar, where the best interest of the child has been followed and adhered to, besides other judgments of the Delhi High Court. Now, friends, a lot of us don't know that there is only one law, that there is only one statutory legislation which defines the best interest of the child. The Guardian and Wards Act is silent. The Hindu Minority Guardianship Act is silent. The Hindu Adoption Maintenance Act is silent. But Section 2, subsection 9 of the JJ Act says the best interest of the child means the basis of any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical and emotional and intellectual development. So left to an enlightened judge, be the district court, be the family court, or be the high court, I think the justice can be easily done to a child if this provision is strictly sought to be implemented. Now, I'm not going into the details, but for those of you who do Child Rights Matters, please read section 3, which gives the general principles to be followed in the administration of the JJ Act. It talks of the best interest of the child to help child develop to the full potential. Principles of family responsibility, that is care, nurture and protection, shall be the responsibility of the biological family. Then section 3, subsection 13, principles of repatriation and restoration, a right to be reunited with the family. Now, this enactment is also finding another enunciation in the National Charter for Children 2003, which had been published in the Gazette of India dated 9th of February 2014 by the Ministry of Human Resource Development, Department of Women and Child Development, Government of India, and it talks in the preamble and in paras rights of the child, where the right as a child has a right to a family, and in cases of separation to be reunited with both parents in the best interest of the child. The common responsibility of rearing the children shall be of both the parents. So friends, if you are in a petition concerning the rights of children, do not look at what the mother is saying and do not look at what the father is saying. Find appurtenant evidence, find documentary proof, find expert reports or whatever material is with you to support the rights of the child, and the parameters in statute and in policy are before you. So this is a very good perspective or a pointer for us to think of a serious shift in which we can look at all these things. I have in my last book, The Rights of the Removed Child and the Law in India, looked in 650 pages, looked at all this in detail, and right now I'm also working on another book, The Global Indian in the Law, where part of it is going to be looked into. So in this perspective, let us see where we are today. Now this is the statute, and as you all know, when we are in a petition, what do we urge? We urge the provisions of the Guardian and Wards Act or the Hindu Minority and Guardianship Act. As you all know, the Guardian and Wards Act is an act of 1890. The Hindu Minority and Guardianship Act is an act of 1956. Now, Section 4 of the Guardian and Wards Act defines who is a guardian as a person having the care of the children of the person of a minor or his property, or both of his person and property. Section 7 talks of the properties of a guardian, power of the court to appoint a guardian. Section 12 talks of interim custody issues. Section 17 talks of matters to be considered in appointing a guardian. And it says that the welfare of the child shall be paramount consideration. Section 19 talks of when guardian is not to be appointed. And it very clearly in Section 19b says that if a mother or a father is alive and is not declared unfit, the court cannot appoint a guardian. Then Section 25 talks of the return of ward to the guardian if a child is removed from the custody of his natural parent. So friends, this is a rundown of the Guardian and Wards Act 1890. It was made at a time when the British thought of an enactment. I will just in a moment come to what the Law Commission says about it. But first, the Hindu Minority and Guardianship Act. Now, the Hindu Minority and Guardianship Act made in 1956 in Section 2 says that the Hindu Minority and Guardianship Act is supplemental to the Guardian and Wards Act. It is in addition to and not in derogation of the Guardian and Wards Act. So, principally, the HMGA is a supplemental legislation. It is an enabling legislation. It is not the principal legislation. Section 4B talks of the definition of guardian, and it includes the natural guardian. Then Section 6 is where the parental rights come in. Section 6 says that the natural guardian of a child shall be the father and after the mother. But Geeta Hariharan's case by the Supreme Court says that both are equal. And the most interesting part is that the custody of a minor less than 5 years of age shall be with the mother. Now, I pause here for a moment. Let us understand it is only the custody of a child of 5 years of age which is to be with the mother. Even if the custody is with the mother, the guardianship is still with the father. Both the father and the mother are natural guardians. So, physical custody will not divest the father's natural rights as a guardian per se, because Section 6 is only limited to that extent. Sorry. Now, there is another argument that the residence of the child is the residence of the mother. And this is so said in the perspective of Section 6 because it is propounded by one school of thought that if the child is physically in the custody of the mother, then the residence of the mother is the residence of the child. Now, to this, there is a counter view of a number of high courts which says that the issue regarding the residence of a child is governed by Section 9 of the Guardian and Wards Act, not Section 6 of the Hindu Minority and Guardianship Act. In so far, Section 9 of the Guardian and Wards Act says that the guardian judge shall have jurisdiction over a child who ordinarily resides in the jurisdiction of the court. So the ordinarily resides jurisdictional issue is based on the principles enunciated in Section 9 of the GWA. And in view of what Section 2 of the HMGA says, that it is only a supplemental legislation and not in derogation of any other legislation, the rights, so to say, appurtenant vis-a-vis custody pale into insignificance if we talk of a superior right of custody and of residence vis-a-vis HMGA. So if a court has to decide what is the jurisdiction, then the court has to decide as per principles laid down in Section 9 of the Guardian and Wards Act. And Section 9 of the Guardian and Wards Act, as has been interpreted by a number of courts, means to say that this is the place where the child habitually and normally resides, not the date on which the child is residing, on which the date a petition is filed, not where a child is retained or forcibly kept. Now, what is a habitual residence, physical residence? This will obviously need to be established by facts. But Ruchi Baju's case by the Supreme Court, Justice Thakur, very elaborately says that if a guardian judge has no jurisdiction, then the guardian judge can pass no order. But this is dehors the power of the High Court in a 226 petition, that is under the Constitution of India, say habeas corpus, where a High Court exercising parents' patrial jurisdiction has exclusive rights, and any limiting factor of jurisdiction under Section 9 will not divest the High Court of passing any order, maybe for retaining the child, maybe for sending the child's custody issue to the Guardian and Wards Act, or a decision by the family court or the guardian judge, or asking the court, or asking the parent concerned to go back to the country from where the child was removed. Now, this, friends, is the broad scenario where we are. Now, the Law Commission in report number 257, Reform in Guardianship and Custody Laws in India, looked at these issues very seriously and seriously recommended joint custody and reasons for adopting joint custody. Now, this report is worth reading. It has not found acceptance, but it is definitely noteworthy to say that this report looks at what is the concept of joint custody, what is shared custody, what are the advantages. It looks at the definition which has been given. There is a Bombay-based NGO called Child Rights Foundation, which has given a definition of child access in child custody. It says child may reside alternately, 1 week with the custodial parent and 1 week with the non-custodial parent, and that both custodial and non-custodial parents share joint responsibility for decisions involving child's long care, welfare, and development. Now, this is a very good definition. Now, the report also looks at reasons for adopting joint custody. They do not really advocate any presumption in favor of equal guardianship for both parents, but Section 6 of the Hindu Minority and Guardianship Act is already saying that both parents are natural guardians. So that may perhaps not be a very contestable issue. Now, they have recommended drastic changes and talked of parenting plans, etc. And they have given suggestions on how to amend the Guardian and Wards Act and the Hindu Minority and Guardianship Act, but obviously nothing is found further. Now, what is very interesting is that this judgment has been noticed by the Bombay High Court in Tushar Vishnu Bale versus Archana Tushar Bale, AIR 2016, Bombay 88. And Justice Mridula Bhatkar has done a wonderful job in coming out with some very blunt principles and concepts which are very noteworthy. And she quotes Justice Dalvi, Roshan Dalvi, who in his workshops used to say, rhetorically, but she says, but aptly, that the word family means F for father, A for and, M for mother, I for I, L for love, and Y for you. So the word family, according to Justice Dalvi, means father and mother, I love you. Now, this is such a stark and such a hitting proposition. And Justice Mridula Bhatkar very rightly says, you may be a bad husband, you may be a very bad wife, but you may be a very good father, you may be an excellent mother. So in this perspective, parenting plans, arrangements of mutual custody, rule of single parenting are, they say, an exception. So it is in this perspective that the court is talking of a parenting plan and custody plan, and in this case, the court has actually done it. The court has said 10 days father, 10 days mother. So this is something which has, and this is something which has come from the Law Commission report. The Law Commission report is extensively referred to, and the principle underlying is the principle of the welfare of the child. I have myself got this principle followed in a very bitter custody dispute between a couple, the father and the mother, over their only son, who is loved fiercely and very emotionally by both the father and the mother. They have serious matrimonial differences which they are trying to resolve, but they have not been able to resolve. Both of them want the child to themselves, but the child wants both the father and the mother. The child was taken away by the father. The mother unsuccessfully tried in the habeas corpus and then went to a guardian judge. We went to the guardian judge. We got interim custody. It was challenged in the High Court. Now the High Court devised a very good formula. It says Monday, since the child was being schooled in place A, so the court said Monday to Friday, child with mother in place where he is being schooled and where he is staying. Friday evening, the child is to be handed over to the father. And on Sunday evening, the father will return the child to the mother. So the child has access, love, control, contact, affection, care of both his parents. So this, friends, this hypothesis of shared parenting, joint custody is not an alien thing which we can't come to. And how and why can we do it? Very simple. The Family Courts Act 1984 gives complete freedom to a family court judge to devise ways and means of resolving the best interests of the child. And in this perspective, the court is free from the rigors of the Evidence Act and the Civil Procedure Code. It's not bound to follow it. It's free to coin its own procedure. So stricto sensu, if you have any documentary evidence or any material which you wish to put before the court, it need not need formal proof of the law of evidence. If the judge is prima facie convinced that that evidence is noteworthy, it can proceed. I have myself seen a family court judge in a custody matter observing that the child is severely alienated and I would need a psychologist's report. So this is the perspective of the judge. How is the judge free to do so? Because the judge can coin his or her own procedure. So this is a time when we can innovate. Looking at this in a bigger picture, I am a fellow of the International Academy of Family Law Lawyers, so I have an association with family law lawyers worldwide. Australia has done very well. Australia has a dedicated family law judiciary, a dedicated family law bar. There are over 5,000 exclusive family law practitioners, and they start with mediation and alternative dispute resolution in any litigation. The Family Court of Australia is headed by the Chief Justice of the Family Court of Australia, who decides what is to be done in matters pertaining to the family courts. And the Family Courts of Australia has gone so far that they have devised Practice Directions COVID 2020. It is a 50-page manual which is looking at the entire procedure of how family court litigation is going to be handled in the future. It talks of face-to-face contact, it talks of filing methods, it talks of hearings, it talks of child not to be taken out of the jurisdiction. They have conceivably thought of every possible measure which they can think of. Hong Kong is looking at it very seriously. And I think it is time that even we in India would devise a family court module on how to take family court litigation forward. It may not be possible for every family court to devise its own module. So I think the best thing to be done is that the Judicial Academy of India or any state judicial academy can devise a module and leave it to the family court to follow it and innovate in it or add or subtract to it, and maybe look at things in a perspective in which they can handle things. Now, friends, there is another perspective which I want you to know. The University of Westminster, in a recent study called The Voice of the Child in International Child Abduction Proceedings, has looked at Article 12 of the UNCRC, which talks of the voice of the child. Should we have the views of the child? And in a child-centric approach, they say, hear the children while making a decision in the process. Even the Guardian and Wards Act says that if the child is old enough to give an intelligent preference, the court must ascertain the views of the child. Now, in the conclusion of the report, it is said that the courts need to understand that they are not deciding on a parking ticket. They need to look at the individual circumstances because this is a defining moment in a child's life. So this is something which needs to seize all of us. Now, very quickly, what are the perspectives of a child litigation? Now, we have a string of judgments. As you all know, law in child custody matters is evolved through precedents. In Article 141 binds every court to follow what the Supreme Court says. So we start with Surinder Kaur in 1984, where Justice Chandrachud said, jurisdiction which has the closest contact, following committee of courts should decide on the principle of the welfare of the child. Then it also lays down the parents pay tray principle in return of children. Then the temporary residence of the child is governed, as I told you, by Ruchi Maju. Now, welfare of the child is of paramount consideration. Now, the welfare of the child coming in a child-centric jurisprudence is finding repeatedly enunciation by the Supreme Court. And Perry Kessingra, the latest judgment of the Supreme Court in 2019, following Ashish versus Anupama 2010 Supreme Court says, statutory provisions dealing with the custody of the child under any personal law cannot and must not supersede the paramount consideration as to what is conducive for the welfare of the minor. In fact, no statute on the subject can ignore, eschew, or obliterate the vital factor of the welfare of the minor. So you cannot say that I have the custody under 5 years of age, I am the custodian. If the welfare is not with you, is not comfortable with you in the view of the court, then there is no view. And this is actually said in Lahari Sakhamuri in 2019. This is the most recent judgment in point of time, wherein upholding the High Court judgment of the High Court of Andhra in Soban Kadali, the court says the expression, quote unquote, the expression best interest of the child. Now, friends, this is where the best interest of the child in section 2(9) has found judicial approval. And the court says the expression best interest of the child, which is always kept to be of paramount consideration, is indeed wide in connotation. And now I'm going to stress here, it cannot remain the love and care of the primary caregiver, i.e. the mother in case of the infant or the child, which is only 5 years old. The definition best interest of the child is envisaged in section 29 of the JJ Act to mean the basis of any decision being taken regarding the child to ensure